So as an introduction, my name is Marco Botta. I'm a research fellow at the European University Institute in Florence. And today I have the pleasure to chair the third webinar of our series on the impact of COVID-19 on competition and regulation of digital platforms in Europe. Today we discuss in particular the recent antitrust cases concerning excessive pricing of sanitizer products in Europe, cases that started during the first phase of the pandemic in March, April 2020. Before we start, I would like to introduce you our panelists today. So I have the pleasure to introduce to you Valérie Meunier. She's a Senior Vice President at Compass Lexecon in Brussels. Valérie is an economist. She holds a PhD from the Toulouse School of Economics. And before joining Compass Lexecon, she works for a number of years as Deputy Chief Economist at the Autorité de la Concurrence in France. Our second speaker today is Jean-François Bellis. He's a founding partner of Van Bael and Bellis in Brussels. He's a very well-known practitioner. He has over 40 years of experience in practicing competition law. He's not only well-known in Brussels, but also in Luxembourg, where he has been involved in a number of landmark rulings by the European Court of Justice, like United Brands, that we'll discuss today, Wood Pulp, Michelin, 1 and 2, Microsoft, and also lately the Intel case. And finally, let me introduce you our last speaker today, is Wolf Sauter. He's currently working at the Dutch Authority for Consumer and Markets, and in addition, he's professor at the Vrije University of Amsterdam. During his academic career, Wolf has extensively published in the field of the interaction of competition and regulation in healthcare markets, and therefore he is definitely an expert in the topics that we are going to discuss today. Let me share my screen. So as I mentioned before, the basic question that we are going to discuss today is whether the recent cases of excessive pricing of sanitizer products during COVID-19 can be considered unfair pricing and therefore prohibited under Article 102 of the treaty. Let's bear in mind that under competition law, excessive pricing are not prohibited per se, only when they are unfair in accordance with the case law of the Court of Justice. So I will start with a short introduction, a short presentation. I will then leave the floor to our panelists, and then we will have a Q&A session where the panelists will reply to your questions. So I would be grateful if you could engage in the discussion by asking questions to our panelists. You can type your questions in the live chat. When you write your questions, please indicate to whom you would like to ask the questions, to which panelist, and also select the option write to all panelists and attendees rather than write only to panelists. This is important because we want to share the questions, we want to avoid overlaps and repetitions of the same questions. The webinar today is recorded. In the coming weeks, will be available on the EUI YouTube channel. However, the name of the participants and also the questions typed in the live chat will not be publicly available. So COVID-19 created let's say, fundamental changes in terms of demand and supply for most of the products. For a number of products, the demand substantially decreased, and also this led to a decrease of the price of the products. Think about airline tickets, holiday packages. For other products like sanitizer products, like face mask, hand sanitizer, gels, there was a peak demand, a sharp increase of the demand at the beginning of the crisis in February, March 2020. At the same time, we had a disruption of the global supply chain. The global trade suddenly stopped, and this has caused excessive prices of these products during the first phase of the pandemic. The question discussed today is whether these excessive prices, beside the market dynamics, has also been caused by unfair behavior by manufacturers and wholesalers of these products, and this behavior will be sanctioned under Article 102. Authorities of different EU member states have reacted to the excessive prices of sanitizer products. For instance, in France, the Ministry of Economy introduced a maximum price on hand sanitizer gels at the beginning of March. As far as I know, no other member states introduced a system of price regulation for these products, while a number of competition authorities in the United Kingdom, in Poland, and also in Italy have open investigation concerning these excessive pricing cases. 2 points that I would like to underline about this investigation. So first of all, the investigations are currently pending. To my knowledge, no authority has still adopted any decision. So it might well be that at the end of the day, this authority will close the cases without adopting any infringement decision. And secondly, it's worth to be noticed that the authorities that have open investigation on these cases are authorities that have a double hat in competition and consumer law. So it might well be that in a second phase of the investigation, this authority will switch the legal base from competition to consumer law protection. We will have to see. What is unfair? So industrial economics does not provide a clear answer of what is unfairness. It's usually considered a legal rather than economic concept. During the past years, economists working in behavioral economics have conducted a number of experiments in laboratories selecting limited number of consumers for their experiments, and they have developed a number of theories to understand what is unfairness from the point of view of the consumers. Among the theories, the most influential one is probably the dual entitlement theory. According to this theory, consumers accept a price increase if it's caused by an increase of the cost faced by the seller. So if the costs are outside basically the control of the seller. During a period of economic crisis, like the period during COVID-19, consumers become more suspicious about the reasons of the price increase. And the main recommendation of this of the economists who advocate this theory is basically to increase the transparency of the reasons of the price increase. So the seller should explain the reasons of the price increase. So the transparency of the price would cure this unfairness perception by the consumers without any further state intervention. Competition agencies in Europe have always faced a sort of dilemma when investigating cases of excessive pricing under Article 102. Economists usually put forward 3 arguments against the enforcement of this provision of the treaty to sanction excessive pricing cases. So first of all, high prices usually attract new entrants. So the market self-adjusts in the long term. Antitrust intervention is justified only in the presence of high and stable entry barriers. Second, the antitrust intervention could harm the incentive of the dominant firms to innovate, to invest money in research and development, to improve its products. And finally, excessive pricing can also be cured via price regulation rather than antitrust intervention. So we'll discuss this issue during the roundtable with our panelists, but my personal view is that the second and the third arguments are not applicable in the case of the coronavirus crisis. There are no innovation consideration for sanitizer products, and price regulation has been adopted only in France. While the first argument is more debatable. So it's debatable whether the markets for sanitizer products were characterized by entry barriers that justified these excessive pricing cases, or whether this, let's say, this excessive pricing were simply temporary and caused by market dynamics. As we know, to sanction a case of excessive pricing under Article 102, the first step is to prove that the company is dominant in the market, and afterwards we need to find the abuse. The Court of Justice in United Brands has developed a test to assess when a case of excessive pricing can be considered abusive under Article 102. And the test, as you probably know, includes two cumulative steps. So the first limb of the test implies that the price is excessive in comparison to the economic value of the product. So this requires the agency to compare the cost and the price of the product. And the second steps of the test is the so-called unfairness limb. So the price is unfair in itself or unfair when compared to competing products. The second limb has recently been interpreted by the Court of Appeal of England and Wales in Flynn-Pfizer case, where the court basically argued that the second limb includes two cumulative rather than alternative conditions. Since United Brands, the Court of Justice has always recognized that United Brands test is not the only test available to identify cases of excessive pricing. Other methods are available, and the most common methods are the so-called benchmarking approach. So benchmarking basically means comparing the price charged by the dominant firm with a benchmark price, a competitive price. So the competitive price can be identified by a geographic comparison or by comparing the price of the competitors of the dominant firms, or also via a comparison over time. So analyzing basically the changes of the price applied by the dominant firm over the time. For instance, in British Leylands, the Court of Justice recognized that British Leylands abused its dominant position because it increased 600% the fees that it applied for issuing conformity certificates for cars imported from continental Europe to United Kingdom, after British Leylands received a legal monopoly to issue such certificates. Similarly, in the Aspen case in Italy, Aspen increased the price of drugs to cure cancer between 300% and 1,500% after the drugs have been delisted among the list of medicines which were reimbursed by the Italian healthcare system and therefore subject to price regulation. So according to this last benchmark approach, which might be let's say, valuable in the analysis of the excessive pricing cases during COVID-19, it would be possible to compare the price before, by the dominant firm, before and after a specific event. So in our case, it would be before and after the start of the coronavirus crisis. Even if we identify a specific benchmark approach that it's applicable to the case, then the next question is to understand when the difference between the price charged by the dominant firm and the benchmark price is sufficiently high to be considered unfair. So there is no minimum threshold according to the case law of the Court of Justice, but the difference has to be appreciably high, significant, and persistent. And this last word might be relevant in the case of the excessive pricing cases during coronavirus 19, since, as I said before, this increase of the sanitizer products price were rather for a temporary period of time rather than persistent over a long period of time. Finally, it's also worth to bear in mind that unfairness has to be confirmed by multiple tests, so a single test is not sufficient because the analysis is very speculative and the risk of false negative is very high. And also the dominant firm can put forward some objective justification to explain the reasons of the excessive price. So as you can understand, the legal test to prove a case of excessive pricing under Article 102, it's very high. There is a very high burden of proof for the competition agency. And this is understandable because in competition law enforcement, excessive pricing cases are exceptional cases. Even if a competition agency will find enough evidence to sanction this type of case in the context of COVID-19, then the next question is, what would be the applicable remedy? I mentioned before that in France, the Ministry of Economy introduced a system of price regulation since March 2019 for the hands gels. But we know from economics that when excessive prices are caused by supply disruption or increased demand, price regulation will simply further increase the problem of shortage of supply. Under competition law, we have different remedies available beside the fine. These remedies could be structural remedies, behavioral remedies. But one basic question in competition law enforcement is the timing. So an agency requires years to complete an investigation, and an infringement decision is then subject to appeal in court. Last week, Commissioner Vestager talked at the last Scholar conference, the annual conference of the competition law scholars, and she talked about the remedies in competition law. She mentioned that the remedies are slow, let's say, especially in relation to the quick dynamics of the digital economy, and she argued in favor of a more, let's say, reactive approach by competition agency. So, for instance, a few months ago, the European Commission adopted in the Broadcom case interim measures, and this has been the first time in the last 20 years. Last time, Commissioner Vestager clearly argued that interim measures are expected in the future, they will be more common, and therefore it might be worth to discuss also the use of interim measures to stop cases of excessive pricing related to sanitizer products sold during COVID-19. So I stop here. I would like now to leave the floor to our panelists. So first, I would like to ask Valérie what is her opinion as an economist about these recent cases concerning excessive pricing of sanitizer products. Are these investigations justified by market failures? Are also the traditional arguments put forward by economists against antitrust enforcement vis-à-vis excessive pricing valid in these cases? Then I would like to ask a question to Jean-François Bellis about the application of the United Brands test in the context of excessive pricing cases of sanitizer products during COVID-19. Is this test, let's say, feasible? How could the antitrust agencies that are investigating this case apply this test? And finally, I would like to ask Wolf Sauter two questions about remedies. So, in your view, what would be the most appropriate remedy in case of excessive pricing cases of sanitizer products? And what would be your view about the role of interim measures in the context of these cases? So I stop here and I now leave the floor to Valérie to reply to my question.
Thank you very much, Marco. Well, first of all, hello everyone, and I hope everyone is doing well and is healthy. This is not my bookshelf, okay? So I stole a picture from the internet, and this is the nice perk of Zoom. So you know, I can hide my messy background and just have a little fun. And then third, thank you for inviting me to speak. So you've seen the questions that have been addressed to me, and then I've used those to organize, to structure my talking points. So the first issue is whether those excessive prices during the COVID-19 crisis were caused by market failures. Very short answer is yes. I will develop further. And the second issue is whether those excessive prices justify the intervention of competition authorities, which can be developed into two different points. One, the question of what are the conditions or the circumstances where a competition authority should intervene, and whether those circumstances fit the current context. So to start with, the question is whether excessive prices that we have observed recently for hand sanitizers or face masks are caused by market failure. Well, the short answer is yes. You know, we observe during or following, you know, natural disasters like earthquakes or hurricanes or widespread disease that we are seeing now, we see sudden and unexpected surge in prices, in demand for certain products. And at the same time, the disaster may also cause a very fast drop in shortage, or even the absence of supply altogether. So it means that the previous equilibrium is completely out of the window. And prices, you can see prices increase by hundreds or thousands of %. And on the supply side, production sites are disrupted, transportation is disrupted, so that what seems like very basic and simple products like face masks, like bottled water after an earthquake or a hurricane, they exist by millions and millions. There's no scarcity in general, except that they cannot get to where they are needed. So by definition, this is a market failure. It means that there's a problem in the proper allocation of resources, that the market doesn't work. And what we see here is that high prices are a symptom of markets not working well. They're not a cause, they're a symptom, they're a consequence. And the best is to actually try to deal with the cause, or the causes, even plural, of the high demand or the low supply. And this is how I can transition to the second question. Now that we have established that there's a market failure, do they require antitrust intervention? So in my opinion, in those particular cases, they don't. Of course, don't get me wrong, intervention is required, but in my opinion, there are other legal or regulatory means that can allow for a faster resolution, first of all, because time is of the essence. And that can also address the causes of the problem, not just the high prices themselves, but why those high prices arise. So in general, you know, why outside of the crisis context, what would we find high prices? What would we find any positive or favorable argument to high prices? Well, we would say, well, it's not a big deal because high prices would attract entry, would attract competitors, and the market would correct itself. Second argument against intervention would be, well, high prices have a signaling value, in some environment where there is uncertainty about entry, uncertainty about the incumbent, uncertainty about the quality of a good, prices can be used as a signal, okay? So if you prevent the use by companies of high prices, then you can prevent this sort of tool to signal to the market or to competitors or to consumers the quality of their good or their intrinsic characteristics. Third, also another reason why high prices may be sometimes be needed is that the high prices are a reward for high investment or risky investment. And when you have a firm that takes a route, you know, several investment decisions at the same time, some are more risky than others. And if you curtail the prices, it means that there are some options, that there are some potential investment that the company will not take because you take away the possibility of a high reward in the future. So some economists and some commentators and some scholars and practitioners have considered that the intervention by a competition authority should be limited to sort of extreme or rather extreme circumstances or conditions. So one of those would be, you need to be on a relevant market where you have a dominant company that has a monopoly or a near monopoly position that is not the result of past investment and innovation, okay? Because if that were the case, then you have to take into account that you want that company to be rewarded for its investment so that it doesn't prevent future investment. It doesn't chill innovation. There has to be very high legal barriers to entry. And then you need to find that prices widely exceed any measure of average cost, including a necessary return on risky investment, okay? Not just a reasonable return on investment in certain circumstances, but also taking into account the return on risky investments. And you want also to intervene when those high prices can prevent the emergence of new goods or services. And you want to intervene when there is no other obvious solution that exists, for example, like a sector regulator, okay? So how does the current crisis fit into those conditions? So we will, in the next points that I want to make, we will address some of them. Here, obviously, what we see is that there are some barriers. There are some barriers to why we couldn't get hand sanitizers, we couldn't get hand masks, but they were not legal. They were because the supply of those products, there was no stock to start with. Okay, so that was a big issue in France. There was a stock of masks, but that was outdated. Okay, that had expired from the previous SARS crisis. So we didn't have any mask here. We didn't have any companies able to produce those masks. And even if there were some masks, transportation was also highly disrupted. And that was the same for hand sanitizers. So those barriers are not really legal, and actually, I would argue that this is what needs to be addressed if you want to prevent those high prices. Why? Another reason why I think it might not be a competition authority might not be best placed to intervene is because. And Jean-François Bellis will talk into more detail about that, is that, as you were saying, Marco, the standard of proof is really high. Here we're talking about an exploitative abuse of a dominant position. So it means that, first of all, you have to define a relevant market. So in terms of product, that may be easy, but in terms of geographical relevant market might not be that easy, okay? Given internet sales and given the fact that people cannot move, but they can order on the internet, that's very, very complex. Second, you have to say the competition authority has to assess the difference between the cost incurred by the company and the price charged, and conclude that price was above cost persistently. Well, can you put?
Sorry, Wolf, could you mute yourself? Yeah.
Yes. Okay. So then there's the price cost difference that needs to be calculated. And that can take some time. And third, you have to demonstrate, this second leap of the United Brand Test, whether the price is unfair in itself or compared to competitive product, but actually not be the hardest limb here in that case. Here, what I would argue is that first, finding a dominant position might not be easy. We have seen examples of individuals who manage to corner the market, okay? So you have one person getting his or her hands on a pile of masks and then selling them, quite illegally on the market. So this is not a problem of a dominant company. This is an individual who's cornering the market for masks or for hand sanitizers. So that is not an issue that a competition authority can address. Then, as you were saying, Marco, the other problem is that the case law says that you need to observe high prices or excessive prices that are persistent. And here we see a really clear contradiction between the fact that we're in a crisis, we want to act very quickly and very swiftly, but at the same time, a competition authority would have to show that those high prices have been persistent. So there's a clear contradiction here. And the fact that we want to prevent those high prices becoming persistent requires to demonstrate that they have been persistent. So there's a clear conflict here of the reality of the objective and what needs to be shown. And finally, I would say that a competition authority also doesn't have the tool to actually make prices decrease, okay? From the case law, what we have seen is that, so we have findings of excessive prices, but we don't have any guidance on what is the level of profitability below which it's okay, the competition will not find prices excessive, or on the contrary, a level of profitability above which for sure a competition authority would find a price excessive. And understandably, maybe competition authorities have refrained from making such a judgment, which in circumstances like this current crisis is not helpful, because what we need prices to go down to a level that politically or within the society or philosophically we find fair. So overall, what I would say is that first there's the issue of timing, okay? Starting an investigation, and even in the context of interim measures, I would say, even interim measures, you need at least 3 or 4 months to issue them and maybe enforce them, I don't know how. So, but that can be too long in the context of a crisis. And second of all, it doesn't address the causes of those high prices, okay? So overall, what I would say is that in those particular cases, I think other forms of intervention are better suited. They can be quicker, they can be more targeted. For example, I would give so I'm French and I've been confined in Paris since March. In the early period, we didn't have any masks, okay? So we were at home, and even essential workers like health workers or people still working, cashiers and people working in shops, they didn't have a mask. And that was a huge problem. So what the government decided was to requisition the existing masks and then to redistribute them to essential workers, until the time the supply of masks increased. And then, so there's this kind of tool. There was also incentive for suppliers who were not producing mask or hand sanitizer to divert their production to those productions. So like wine producers, for example, who could not sell wine, started to produce hand sanitizers if they had enough technology to do so. All over the country, you had people starting to make fabric, to make face masks in fabrics, etc. So I think that is better at solving the issue. You try to address the issue of lack of supply, and then you prioritize transportation to where those products are needed. I know that the CMA has launched a task force. There was a joint communication just a few hours ago, and they're monitoring the market. But it just so happened that the CMA is also an authority that has the possibility to apply consumer protection laws, which in my opinion is very important for those particular cases. And then more generally, I think in those circumstances, you know, you have to ask yourself, what is a fair price? What is, as a society, the price that we want, or a maximum price, or, you know, the given price that we want to have for a particular product at a particular point in time? And for that, you might want to apply a standard that is not just the consumer welfare standard that a competition authority is supposed to follow or to use. You know, if you want to give incentives to suppliers to supply some products, then you don't capture that with a consumer welfare standard, or not only. So you need a broader welfare standard, in my opinion, to look into these issues. I don't know how long I've talked, but I'm going to stop here.
I think you cover a lot of issues,
yeah.
even beyond the questions, but I think it's your contribution is very worth, because you are the only economist among the panelists, so we appreciated your intervention. I will now, first of all, like to remind the audience that they can type their questions in the live chat. Please select the option write to all panelists and attendees. You can write a question for Valérie, but also for the other two panelists. And I would now like to give the floor to Jean-François Bellis for his legal perspective about these cases.
Thank you, Marco. Also, good afternoon to all the participants. As a veteran of the United Brands case, I'm frequently asked to address the issue of the United Brands excessive pricing test, and whenever I'm asked to do this, my immediate reaction is always to tell, so you mean the so-called United Brands excessive pricing test, because I feel that this test is taken much too seriously and also much too literally. The court itself in the judgment made it clear that, well, this so-called test was only one method for determining whether a price is excessive. There were other methods that could be used, though the court did not elaborate on what they could be. And I think it's very important to bear in mind that the test is simply a reaction by the Court of Justice to the approach taken by the Commission in that specific case. And so just a few words about what the Commission did in United Brands. I think it's useful to remember this. It's a case where the Commission did not conduct any cost analysis. It based its finding of excessive pricing essentially on the price comparison between the prices charged by United Brands to its customers in the Benelux, Denmark, and Germany, with the price charged to United Brands customers in Ireland. But the comparison was flawed because on the continent, the bananas sold by United Brands were sold on a free on-rail basis. The customers were taking delivery of the bananas in the ports of Rotterdam and Bremerhaven and transported them at their own cost to their location in each country. But in Ireland, it was different because previously the United Brands ships stopped at Cork in Ireland to unload the Irish bananas, but United Brands thought this was too expensive to stop a whole ship just for a few bananas to unload in Ireland, and so decided that the Irish bananas would be unloaded in Rotterdam and then transported by truck to Ireland. And so the price for Ireland was a delivered price. Now, if the Commission had compared the delivered Irish price with the free on rail continental prices, it would have found that the prices were not all that different. But it deducted the cost of transportation of the Irish bananas from the Irish prices, and so found these huge price differences. But that cost incurred by United Brands to transport the bananas to Ireland was a cost which you could regard as a cost incurred for the benefit of the entire shipment of bananas coming from Central America, not just for the Irish bananas. And so it's on the basis of this very flawed comparison that the Commission then inferred that since the Irish prices were profitable, at least this is what it had asked United Brands to confirm initially, the prices charged elsewhere were very much higher and so were excessive. Now, I won't go into all the details of the story. The case initially started as a predatory pricing case. People in Ireland had complained that the prices in Ireland were too low. The Commission asked United Brands whether these prices were profitable, and in the mid-70s, the Commission having no economist, no accountant, the investigations were much more relaxed than more recently. And so United Brands said, yes, the prices are profitable. But then when United Brands understood the use that the Commission was making of this information, it retracted that information and said, well, no, in fact, our prices have been unprofitable for a few years. So that's really the basis of the finding of excessive profit. But then the Commission also looked at, made other price comparisons, comparison between the price of the branded Chiquita bananas and those of branded bananas sold by United Brands competitors and unbranded bananas, and found price differences there as well. So it's on the basis, in that context, that the court developed the famous two-step test. Even though the court noted that the Commission had not conducted any cost analysis, it said that, well, the question to be determined in the case is whether, that's the first step of the test, whether a comparison of the costs incurred and the prices charged shows that the price is excessive, so that there is an excessive profit. And that's the first step. The second step, if the answer to the first question is yes, is indeed whether then this price is unfair in itself or when compared to competing products. Now, all of this simply follow the structure of the reasoning developed by the Commission in its decision. And so the court applied this test to the facts of the case and found that as far as profit is concerned, well, the Commission had not shown that United Brands was earning an excessive profit. The court agreed that enough doubt had been thrown by United Brands on the validity of the Commission's analysis. And it could have stopped there, but it went into the second step, and as far as the unfairness in itself, it noted that prices of bananas had not increased in real terms for 20 years. In fact, they had gone down by 50% between 1950 and 1970. And as to competing products, the price difference, 7%, was not excessive. And so the court then concluded that the Commission had failed to establish the existence of an abuse. Now, how can this be applied to the case of hand sanitizers? First, the question of dominance. Is there dominance? And here I would like to remind people of a case which probably everybody has forgotten, but I remember it well because this was my second case after United Brands, BP and the ABG oil company's decision in 1977. Also a case taken in a situation of crisis, the oil crisis with shortages, in which the Commission developed a very special concept of dominance, finding that in a situation of general shortage, each company that has access to supplies is in a dominant position in relation to its customers, who are totally dependent of that supplier because they cannot turn elsewhere because of the shortage. And so I don't know the facts, of course, of these hand sanitizers cases, but that concept could be applied here. The ABG oil company's decision was annulled by the court in the BP case 7777, but on a different ground, the question of the abuse. The court did not address the question of dominance, though Advocate General Warner did. So, well, maybe in this case, you could find some situations of dependence that justify a finding of dominance. Excessive profit, well, here it must be easy to determine the cost of a hand sanitizer, and probably we will see that the prices indeed must have produced a very high profit. But then, is this unfair in itself, or compared to competing products? If you compare to competing products, you will find that probably the same prices have been charged by everybody because of the shortage. And then, is it unfair in itself to take advantage of the laws of supply and demand and charge high prices in a situation of shortage? I see this more as a moral than a purely legal issue. But then, and I will come to my conclusion because I'm trying to stick to my 10 minutes. One thing that is very striking about United Brands, and again, something that people have forgotten, is that what the Commission was trying to do in United Brands was to address a very broad economic issue, inflation, which was very high in the mid-70s. And all competition, well, a number of competition authorities were trying to use competition law to deal with inflation, especially the Bundeskartellamt. And I think that the reference to the court, by the court in United Brands to other methods of comparison is a reference to what was done, especially by the Bundeskartellamt, with the use of the concept of Als-ob-Wettbewerb, as if competition, competitive markets with which you make a comparison, etc. But I mean, this attempt was vain because antitrust provides micro solutions which cannot address a macro problem. And my impression is that the problem of hand sanitizer is also a problem which is the result of a situation which is a market situation to which you cannot give an answer by just going after one or two companies and finding them. And so, like Valérie, I would agree that probably this situation calls for a regulatory answer rather than an antitrust intervention.
Thank you very much, Jean-François, for your historical perspective about the United Brands case. Your point is very relevant. I mean, the case law that we have from the Court of Justice, the different tests are simply developed by a reaction of the court to the preliminary rulings that the court received from national courts and also to the Commission decisions. And that's why we don't have a consistent framework to apply. We already have one question from the audience, and I invite all the other attendees to write their questions to the panelists. But before we move to the questions, I will first like to give the floor to Wolf Sauter for his perspective about the remedies. Please, Wolf.
Good afternoon, everyone. Thank you, Marco, for inviting me to speak, and thank you, Valérie and Jean-François, for your insightful comments. I'm wearing two hats today, one of the university and the other of the competition authority, but I'm going to speak primarily from a practical perspective. So the two questions that I'm supposed to answer is what is the most appropriate remedy in case of excessive pricing of sanitizer products during COVID-19, and the other one is what is the role of NCA's interim measures in the context of excessive pricing cases. I will first provide some context, then I'll answer these questions and draw provisional conclusions. First, as regards the problems posed, we've discussed high prices for sanitizer products. So primarily, these involve price increases, and as we've seen, it's generally related to a problem of scarcity in supply. So what we need to do is not just control prices, but increase capacity by doing things like attracting new sources of production. In the Netherlands, that has been beer and spirits producers producing alcohol, and we've just heard that in France, wine producers were doing the same. In the Netherlands, we haven't so much been confronted with high price for sanitizer products as with scarcity of COVID-19 tests in the context of medical devices, where there's a dominant provider of test equipment, which is Roche. And because of that dominant provision of test equipment, there's a bottleneck there. Roche holds proprietary standards for liquids and plastics, was completely unable to supply demand. So what you see as a result is denial of health essential services and excessivity in a sense, which is excessivity in the sense of an infinite price because nothing is being supplied. So I would say that in the context of a health crisis, the real problem is not so much price, but availability. And an obvious commonality between the different problems just mentioned is the need for speed to do something. We don't need procedures that come to a conclusion 12 months after the act or even later. So I'll first say something about interim measures and then about alternatives. Regarding interim measures, the problem is that interim measures can be a remedy if they're available. However, they may not be available in all member states, to all national competition authorities, and more generally, there's very little experience with interim measures in competition law, especially where it comes to protecting consumers directly. We do have some guidance, that's the standards that are provided by the ECN Plus directive, which will come into force or be effective in the member states in a practical sense only in February next year. And there are three standards there. The first is there has to be prima facie evidence of abuse, which can be linked to the price hikes that were mentioned before and the concept of temporary dominance related to that. The second condition is serious and irreparable harm, which means that it's something that cannot be rectified fully by damages payments after the fact. And irreversible health damage would seem to be something that falls into that category. And thirdly, there has to be a proportionate remedy. Now, if you want to start thinking about something like fines, you're delaying the process considerably. It may be more productive to link periodic penalty payments to something like a price cap or alternative price controls. That might be a more reasonable remedy. And in addition, what you may want to be thinking about is imposing these as temporary measures and to see whether or not they are reversible. The second category is alternative remedies, and I would classify those as to do whatever it takes, considering the urgency of the situation. In the first place, you want to try to increase output and grow supply. There are various things that are conceivable. All member states have, under their national rules, implementing Article 31 TRIPS, something that allows them to impose compulsory licenses. That's something you can consider if the legal infrastructure is in place. Speaking for the Netherlands, I would have to say it's not in place, and we're not in a position to impose compulsory licenses in an effective way at present. Possibly using the competition rules, but certainly not the structures that were intended to do so as the main source of such licenses. Secondly, intellectual property rights have to be a solution in order for this to work. And for some pharmaceutical products and medical devices, that may be the case, but it's not always so. For example, in the case of Roche, intellectual property rights were not the issue, it was proprietary standards. The second category of solutions is judicial injunctions, which can be imposed by judges who may be able to do something there. And thirdly, and possibly most effectively, is public and popular pressure and outrage in the media. affecting the reputation of companies and their social license to operate. And in some cases, this even extends to unpleasantness like physical threats to plants and employees of these companies, putting pressure on them to do something. And what could that be? What could they do? Scale up by bringing new production lines in, by bringing new tire producers in. They can open up proprietary standards and processes and or provide licenses on their own accord. In the Dutch case, what Roche ended up doing was sharing its secret formula with the public task force, which was then tasked with identifying alternative producers to scale up production. And in addition, they offered full technical support for all the measures that I just mentioned. So they came across and decided to be fully supported. Now, this can, of course, be a serious problem for the undertakings involved, because some of these measures may not be reversible. So they may be willing to help out during a health crisis, but they also have to be aware of the consequences for their business model in the long term. So that's a balancing act that they have to perform, and so do the public authorities who want to put pressure on them to carry out such measures. And the second main category that is of relevance here is socialization of redistribution and allocation of the resources that are available. If you do that, so there may be a public task force or the public authorities may be tasked with distributing what is available. This protects dominant companies from political and social pressure and allows them to focus on production issues, and that in turn can promote output in and of itself. So to remain within time, I'm going to conclude on a number of points now. In the first place, as far as objectives are concerned, I think increasing output and allocating resources fairly is just as important as controlling prices in this context. And doing it quickly is another important element. As far as instruments are concerned, interim measures may not be available, nor may compulsory licensing, because IP rights may not be essential. And I think in the case of sanitary products, that is highly likely to be the case. But investigations, competition investigations may still be useful to channel, focus, and exercise pressure. So they both take pressure from the companies by channeling it in a possibly more structured and rational manner, and at the same time they allow the competition authorities to focus on solutions. At the end of the day, what you need is cooperation. So working with dominant companies to provide commitments may be the most effective way to go, especially if you're looking for effective solution in the short term. To some extent, such commitments will have to be open-ended, so they cannot be complete contracts. They have to be combined with public measures and planning to increase supply and coordinate distribution. In terms of outcomes, some measures may well be irreversible, as I've just mentioned, and this involves a balancing act for everyone concerned in pursuit of a common objective of public health in the pandemic context. So those were my remarks. Thank you for your attention. I have some slides here that I can make available after the webinar.
Thank you, Wolf. Yeah, indeed, we will upload my PowerPoint and also your slides on the website of the webinars, where you will also find in the coming days also the recording of the webinar. So thank you for your perspective about the remedies and detailed discussion in relation to the different challenges that an agency would face in imposing different type of remedies in these cases. So we can now open the floor for Q&A session. So we have one question. I think it's addressed to all of you. So then the question is the following. How much of this sophisticated discussion would apply if one pharmaceutical company finds a vaccine and charges, let's say, 2,000 euros per dose because it has to compensate its innovation effort? So the idea of the question is the following. We are talking about excessive pricing of sanitizer products. Maybe a mask costing 30 euros, it's very expensive, the price is excessive, but it's still affordable, let's say, for most of us. Would that be the same type of reasoning that what we have discussed today? Your arguments would be the same if, in the case of pharmaceutical company, imposed a price of 2,000 euros per dose for the vaccine to coronavirus. Would that be the same, or would that be indeed the case of unfair pricing? Who wants to reply to this question? Valérie or Jean-François, who wants to intervene?
I can just say that this is the problem of the vaccine against, COVID-19, this coronavirus, or any other discovery that can cure, a widespread disease or virus or whatever. It's the same problem. You on the one hand, you need companies or research department to spend some money to do the research. Okay, so they have to have some guarantee that they're not sure they're going to win. Okay, I don't know how many research lab currently looking for a vaccine, and not all of them will win. Okay, so this is part of their business model, but this is also why at national or even European level, there is this willingness to pool money and to sort of subsidize research also, so that this problem would not arise. And then second, I think this is a question also where the health regulator needs to be involved, because that's what they do. That's their remit. That's what they were created for in countries where there exists and where there is social security. So I will stop there because I'm sure the other panelists have a lot to say.
Yes. Yeah, maybe I would like just to say, and I basically, share Valérie's view in this. The question posed is a very difficult one to answer in antitrust terms. But I know that the past cases in the last few years where the issue of excessive prices has been raised in Europe, were cases concerning off-patent drugs. So when you have, a new vaccine, something that everybody's waiting for anxiously, and what is the right pricing for a product like this? You have to take into account, of course, the incentives also for companies to invest in that what may be a massive effort. And I think it's very difficult to give an answer, an antitrust answer to this based on, if we take the United Brands test, unfair in itself. How can one judge this? I think this is really something which, again, I would leave to regulators and companies. I think it's very hard to give an antitrust answer to that question.
Okay, Wolf, do you also want to intervene on this question? I don't hear you. I think you need to unmute yourself.
I think if such prices were to be charged for corona vaccine, it would stand to reason that the company involved would open their books to illustrate why they think this is a reasonable price as a preemptive measure in order to avoid a lot of difficulties for everyone involved, I think. As far as the test that we've heard, I think on the one hand, it's based on cost and a reasonable return, and that return has to be reasonable in relation to the degree of innovation involved. So I think we would agree at our competition authority, we're looking at such cases in there. We think innovation and the measure of the degree of innovation is a very important variable in that respect. So that would be highly relevant. And from that perspective, it's impossible to say in advance whether a price of 2,000 or 3,000 euros per dose would be unreasonable or not. But it might well be, but it equally could be reasonable. It depends on the facts of the case.
Yeah, of course, we will see, and hopefully we will not face this type of situation. We have another question. Perhaps Wolf will be in the best position to reply to this question. So in the aftermath of COVID, do you see an increased collaboration between competition and consumer protection authorities in countries where these two authorities are not merged, but they operate independently? So what is your experience about the interaction between competition and consumer law protection, let's say, from the point of view of an enforcer?
Well, I represent an authority that includes both types of activity. So we are in a relatively comfortable position. I have to say that the reality of it is that there are so many issues coming at us right now that although there is coordination, we both, at both ends, we have a full plate of issues. And it's not a case where we're having to decide which to apply and which to apply jointly, but it's mainly being a matter of almost crisis management and responding to things. But I think as a longer term trend, it's definitely going to increase collaboration between these different branches of the same authority, and or between different authorities in those member states where these responsibilities are allocated separately.
Okay, thank you. So I think we are already 5 minutes beyond time, so we are running out of time, and I'm sure we could discuss this issue for hours. Wait, there is still one question that it might be worth to discuss. How will competition remedies guarantee affordability and quality, given that this will be the most political vaccine of all times? In essence, can we conceive any globalized competition regime for sectors that serves an economic pandemic effect such health? Who would like to discuss this question, to reply to this question?
I think it's a good question, but it's quite beyond, you know, what I don't think this is in the remit of a competition authority. If we want to talk about quality and affordability of a life-saving vaccine or medication, this is completely outside and beyond the scope of a competition authority. I mean, this is. Yeah,
indeed, it's a very bold question, and we will have.
It's a very important one, but I think this is, you know, it's a decision taken by the government in a country where you have decided that your society will look like that, or this, but. This is,
it's more a, let's say, political decision rather than a decision of an
and collective in a sense. You know, this is a country and a society, and this is how we want to work. And then, if there's collaboration, you know, within the European Union, for example, between countries, then great. But
yeah, I agree. So I would stop here. I think I'm sure we will have other opportunities to further discuss the issues when these competition authorities conclude their investigation on the excessive pricing cases. So first of all, I would like to thank our panelists, our great speakers today. But I would also like to thank Elisabetta Spagnoli, who organized the webinars. You cannot see her, but she's in the backstage, let's say, but she's doing a great job during the past weeks to organize this webinar series. And finally, I would like to thank all of you, to thank the audience for staying with us during the last hours. I would like to remind you that our series of webinars continues. So next Friday at 1:00 p.m. Central European Time, so the same time like today, Professor Giorgio Monti will share a webinar on the impact of COVID-19 on the pending antitrust investigation in Europe concerning GAFA, so the Apple case, Amazon, Google, and Facebook. So the question discussed in the next webinar is whether and to what extent, after the coronavirus crisis, the antitrust investigation will somehow turn, will change because of the role played by this online platform during the crisis. So if you are interested to join the webinars, please register. For the next webinar, you find the registration form on our website. So thanks all of you, and I wish you a nice weekend and a nice afternoon.